I can't see you.
I am very much there, sir. I'll just put another that on so that.
Edmund, can you please remove this banner?
Yeah, I can't see anyone.
Can you now?
We can see, but this thing is coming now, this banner thing.
Sir, अब हट गया है.
नहीं हटा. It's a host is not allowing participant to unmute.
No, sir, you are already on unmute.
Arey, I am already, but why is this thing banner coming here? Host is not allowing participant to unmute. It is blocking the view.
You just click on it somewhere, yeah, on your screen.
Sir, yes.
Is it fine, sir?
Computer, the banner is not there right now.
Yeah. Hello, Amarjit ji.
Good afternoon, sir. Good afternoon, ji.
Good afternoon. Good afternoon. Hello, Vikram.
Hi, good afternoon.
Vikram, how are you?
The earlier session on land reform got over before the scheduled time.
Oh, that's good.
Yeah. But we had such wonderful sessions, inaugural and on labor law reforms,
Yes.
even on land law reform, except that I think they were short of one speaker. That's why.
संजोग साहब वो दिल्ली हाई कोर्ट में रेफरेंस फुल रेफरेंस कोर्ट रेफरेंस था ना, चल रहा है अभी?
अभी चल रहा है जी, अभी तो शुरू हुआ होगा, अभी तो शुरू भी नहीं हुआ होगा।
तो फिर मेरा 3 बजे वाला मैटर तो निकलेगा नहीं, लेंगे ही नहीं शायद।
नहीं लेंगे नहीं, 3 बजे तो उठ जाएंगे।
हाँ, because there's a special.
We may not even assemble after lunch.
I think so.
Sir, कौन सा मैटर है फुल रेफरेंस?
नहीं, there is a full court today for designating seniors.
अच्छा, 70-80 लोग जो चुनने हैं उन्होंने.
Yes, 70 चुनते हैं, 80 चुनते हैं, 100 चुनते हैं.
Yeah, sorry, it's not a reference. It's a full court meeting.
Yeah, it's a meeting inside the chambers.
Yeah.
Lounge actually.
Then I'm safe. Mr. Basin, I was telling you that it may
Yeah,
clash.
yeah. Good. Kashish, will you check up with Ryan and...
Right, he hasn't. Sir, I'm just checking. They are just joining in. Yes, sir.
And Manoj.
Yes, sir.
See,
Yes,
Mr.
sir.
Jagtiani is already joined, but he's on mute and his video is off.
Yeah. So, Vikram, I will just give a brief introduction about you and then hand over the proceedings to you. Then you can in turn introduce the other worthy panelists.
Okay.
But we have already circulated, you see, the profiles of all the panelists for all the sessions to the participants. But still, a brief introduction would be in order.
Sure.
Sir, they are joining in 2 minutes. Both of them.
In any case, we'll start at 2:45.
Yes, sir. Yes, sir.
You give us a signal to when to start and we'll start. Mr. Manoj Singh has joined. Welcome. Unmute.
Good afternoon, sir.
Good afternoon. Good afternoon. Manoj, we have Mr. Vikram Nankani and Mr. Chandeok here.
Yes, sir. Hello, Mr. Nankani.
How are you, Ji?
Hi,
How are you,
hi,
Manoj?
hi.
How are you doing?
Sir, good, sir.
Hi, Manoj.
Hi, Vikram. How are you?
All good.
So, Manoj, you are back in Delhi.
I am back in Delhi, sir.
You were busy in some big arbitration outside Delhi somewhere.
Yes, sir. I was, sir.
Hello, Haresh Jagtia. Hello. Unmute. Unmute. You are muted, and now it is all right.
So sorry, you must excuse, I come from the Jurassic era. I'm a bit of a dinosaur in these matters.
I come from an era even prior to that. So that is
All right.
we have the youngest entrant, that is Raian Karanjawala.
Okay.
Yeah, young.
He is familiar with all.
I don't know if Ryan has announced this, but Ryan used to be my student. So now he has a perfect alibi. He can blame everything on me.
Yes.
Oh, no.
Lalista, we'll go live in 1 minute.
Yeah, 1 minute, yes.
Just check. Is my audio clear?
Audio is clear. You are visible. Everything is fine.
Fine.
Hi, Manoj.
Hi.
How are you, sir?
Very well. What about you?
I'm fine, Ji. Good afternoon, Ryan.
So we are going
Is it
live.
clear?
Okay.
Is it clear, the audio?
Yes. Clear. Everything.
Should I put my
So
earphone?
with your permission, we start. You see, with your permission.
Now is it clear?
Yeah. So we'll start the proceedings.
Can you hear me?
of this. We can hear you. We can hear everyone. Now we are starting.
Yes.
I welcome all of you, our worthy panelists and the chairperson and moderator, as also the large number of participants who are taking part from all over the country for this very important conference, the Legal Services Summit. We already had 3 very successful sessions. First one was the inaugural session, which was addressed by Honorable Justice Mukundam Sharma, former judge of Supreme Court of India. And the first technical session was on the labor reforms. Again, a very informative, educative session on the new labor codes, which have been enacted and which will be brought into force with effect from 1st April 2021. And the next session, again, a very important session on land law reforms, which was moderated by Mr. Anil Harish. Very successful event where many participants, very eminent panelists participated. And now we have a session on dispute solutions. I have intentionally not used the word resolution, because dispute resolution has, in my humble opinion, but that is my personal view, has failed. All resolution mechanisms, starting with litigation, with arbitration, they have all failed, you see. Arbitration has also failed to take off. Therefore, one is looking for solutions then, because there are disputes. So how do we find ways, you see, to have a solution for these disputes? The emphasis, in my view, should be on mediation and negotiations. Mr. Chadyok is heading, you see, one very important institution, Samadhan, I think, where these disputes are uh, settled amicably with the parties. Therefore, emphasis has to be on solutions like, as I said, mediation and negotiations. What needs to be done is to our law students should be educated in the field of how to negotiate. You see, when some differences arise with among the parties. So this session we have very eminent people to participate, and I'm privileged to introduce to you Mr. Vikram Nankani, who will be chairing and moderating this session. He's senior advocate practicing in Mumbai, but his presence is all over India. He is acknowledged by Legal 500 as a leading individual practitioner in dispute resolution and litigation in India. He regularly appears before various high courts and the Supreme Court of India. And has to his credit several landmark judgments rendered by the courts that have been reported by various authoritative journals and reporters. He has appeared for and before various regulatory authorities in India dealing with foreign exchange cases, electricity, competition, foreign trade, and has also appeared before international arbitral tribunals. He is very frequently invited to speak in various seminars, and that is one reason I have invited him, you see, to not only participate in this, but also to moderate and chair this. And he will in turn introduce our other worthy speakers, who include Mr. Raian Karanjawala and our bar leader, Mr. Amarjit Singh Chandyok, and Mr. Manoj K Singh, founding partner, Singh and Associates. With these words, I hand over now to Mr. Vikram Nankani to take the proceedings further. Over to you, Vikram.
Good afternoon, everybody, and thank you, Mr. Bhasin, for very undeserving words that you spoke about me. Today's panel is as eminent as it can get, and with this robust panel, we will definitely make a headway into the topic which has been introduced by Mr. Bhasin. Just to remind, it's dispute solutions and not dispute resolutions. As he very rightly said, that the corporate world looks at finding solutions. They look at finding value-added options rather than getting entangled into litigation, which not only hampers businesses and transactions, but also adds to the cost element as well. We all know that very often dispute resolution clauses, and I'm here consciously using these words as a departure from the topic, are not given that much attention or importance when corporate deals are struck. When you are sitting at the table discussing how to do business with each other or together, very often attention is paid to the dispute resolution clauses, because while the going is good, nobody wants to think about disputes. But the fact of the matter is that these clauses do play an important role when the need and the time arises. You can't relegate them as a boilerplate clause which is just tucked away at the end of the contract. You can't call them champagne glasses, the champagne clauses, because by the time the parties reach the last part of the agreement which they are going to sign, they're so tired and they want to just celebrate the end of the negotiation that they forget this all-important clause. And that is why we find many solutions to disputes not getting the deserved attention that they should get. With these introductory remarks, let me introduce our robust panel to you. We have Mr. Amarjit Singh Chandiok, who, as Mr. Basin said, has been the leader of the bar. He's the president. He has been the president of the Delhi Bar Association. He is the former ASG, and we will certainly like to hear from him because he has the experience of being on all sides of the table as far as litigation is concerned, as far as court is concerned. We have Mr. Haresh Jagtia, a very eminent senior advocate who also practices in diverse areas and has diverse experience at different levels in different courts. And his insight and his valuable experience will count a lot on this discussion. We have Mr. Raian Karanjawala, who probably heads the largest practice as far as the law firm in Delhi is concerned. Karanjawala and Company is a brand which has stuck around for many generations, and people know about their legal expertise, and it is far and wide spread. Last but not the least, Mr. Manoj Singh. He, as Mr. Basin said, is the founder of Singh Associates, who has a very vast experience in arbitration matters and, of course, the alternative dispute mechanisms. With this, I know that I can spend a lot of time speaking more and more about our eminent speakers, but I think it's important to hear them rather than me continuing with the glory that each one of them does deserve. With these remarks, may I just start the ball rolling by asking Mr. Chandiok the question relevant to the background which has been set by Mr. Basin. We all understand, Mr. Chandiok, the advantages of mediation. Why then in India do you think that mediation is not popular, and why is it not therefore as successful a medium of resolution as it should be? Sorry, you're on mute.
You're mute.
Mediation actually came in 2002 amendment to CPC, and initially, if you all know, in Delhi, when the first mediation center was made in the district courts, the bar went on rampage and broke it down, actually demolished it. Chief Justice Kadju at that time, when Lordship went to Supreme Court later, decided, because he came from Tamil Nadu where the mediation center had been established by him. So he called upon the bar to look at it, but we of course said that if the matter is with the bar will be able to take it. Just to answer your question, there is lack of awareness of mediation even today in many parts of our country. Barring Delhi has done wonderfully well. We have followed with some other parts of like Tamil Nadu has come up, Bombay has come up. In fact, if you'll recall, in Bombay, I had to go all the way to meet Chief Justice Shah to request him that we should have a mediation center in Bombay High Court, and I led a delegation to his lordship to request him. But the fact of the matter is that we need awareness first with the bar, so that the bar has this notion that if mediation is brought about, probably there'll be difficulty for them or some impediment in their practice. The second is the concept of mediation is understood that I have to just sit down with Ryan or with you and probably resolve it out. No, it's a structured situation where a training is required, and that's why on capacity building, only to correct that situation, that in fact we started that Samadhan in 2 rooms, and today we have 32 rooms as part of Delhi High Court, one of the international centers that we have on mediation. Thereafter, we saw, before the Commercial Courts Act, we thought that there was restriction in the court. Therefore, we constituted what we have, Madhyam, as the International Council for International Conflict Resolution, where we now started, and we are now a limb of the Bar Association of India as part of them, and coming up with a structure at Rouse Avenue. Dr. Basin was actually responsible for all that we see it. Now, what we are looking at is that we should have more awareness. People are not aware of what mediation is, and it's actually confused many times with conciliation of Part 3 of the Arbitration Conciliation Act. There's nothing to do with it. In fact, we see, Dr. Vaseem will bear with me, right from Trade Union Act, we had word conciliation added into the statute. But who utilized it? We saw conciliation in a different concept. But today, conciliation as Part 3 of the Arbitration Act is distinct from mediation. And that's why Section 89 of the CPC uses mediation, conciliation, judicial settlement, and that. But when we went to arbitration, if you see Section 30, they use the word any other mode of settlement. So any other mode could be now in insolvency we have brought in consumer forum, we have not brought compulsory mediation. In Commercial Courts Act, we have brought mediation as a compulsory pre-litigation mediation. Now it is taking time, but I can show you in the if you see the statistics the last few years, mediation has grown leaps and bounds. And this pandemic, I saw every third day or fourth day, there was an invitation for me to speak on something because some ODR panel platform was being created for mediation. No, it's all well. We are actually, the Supreme Court created an expert committee of which I had the honor to be a member. We cleared already a bill for mediation, submitted to the Supreme Court, which has scrutinized it and sent to the government, probably because of the pandemic and vaccine probably today taking its toll. Probably it has not come forward. I'm sure when that legislation comes in, we'll be able to make it more foremost. But to add to what Vikram you said, we have taken an initiative and already collaborated 4 universities now, NLU Delhi, Gujarat Law University. We have also done with 2 other universities where we are capacity building from children now, students. We started actually, Justice Nariman's wife is actually heading our committee. So where children are concerned, we have gone to schools now to create an awareness of what mediation can be in the context of a conflict between child and the teacher, or a child and another child or a student. So therefore, the concept is growing. We are trying our best to see that the capacity is built up. And I'm sure time is not very far. We are already seeing in this pandemic as much as 67 to 70% cases either we were able to resolve, parties were able to resolve, or at least we rewrote the contract, especially the force majeure clause. As you rightly said, people don't really look at settled or documents when actually they're negotiating. And I think time has come when we must resolve also to see that mediation forms part of the document when we are entering into a document. And I think that will take care of that. But yes, it is a structured situation. We need awareness amongst lawyers, we need awareness among people, and we need awareness amongst ourselves as professionals that what it can do for them.
Thank you, Mr. Janil. We know, all of us know how successful your drive has been and how successful Madhyam has been. Let's look at the practical side of it. And for this, I will turn to Mr. Karanjawala. How many corporate clients?
Vikram, I couldn't hear you. What was it?
Sorry. My question to you, Ryan, is that how many corporate clients take your suggestions seriously and in big ticket matters when you advise them to go for mediation? I mean, is there, do they really accept it willingly, or is there reluctance? Because while we hear of mediation, cases being referred to mediation, the question is, are big ticket corporate matters going for mediation or not?
No, just Vikram, you're coming very inaudibly. Harish, if you could hear him, could you speak, because your mic was clearer? Could you come across?
Sorry.
Or Vikram, just text me the question.
Yeah. I'll try and do that. I have my volume 100%, so this is the best that I can. But I'll try and repeat.
No,
if you were to advise,
the problem is that it's breaking.
Okay. Is it better now? If you advise your client to go for mediation in a big ticket commercial dispute, what is the general reaction? Do they take it seriously, or they think mediation is a waste of time?
Ryan, can you hear me? Am I clear? You are muted. Ryan, you are muted. You are muted. We can't hear you. Yes.
Vikram, can you just text me the question, then I'll answer it straight away?
Sure, I'll do that. I'll do that. Let me, until then, in the interest of time,
Yeah.
Over to Mr. Jagtiani. Mr. Jagtiani,
Yeah.
we
Do
all
that.
know that you have very vast experience in arbitration. What has your experience in mediation been like?
Well, I think Mr. Chandu certainly put his finger on the button when he said it's really an issue of structure and also telling people that mediation can be, if effectively handled, can really deliver the goods. Not only that, but then it cuts short a lot of procedure. Now, I was involved once in a mediation process under the provisions of under the auspices of the LCIA, and this happened in London. We were in a hotly contested arbitration where at half the stage, a client, the client I was representing, went under the BIFR, and the other side panicked and said that, okay, we must then make they made an application for security for costs. And of course, that matter was heard by the arbitrator, and the security for costs, the costs which were levied on us to protect the other side in the event that they should succeed, was very, very hefty. And we would have had to really scrape at the bottom of the barrel. It was about almost £500,000. So we suggested to the other side that let's go in for mediation, have a shot at it. If mediation succeeds and a settlement is arrived at, then that could be a part of the award. So we did that, and the other side fortunately agreed. Now, this was my experience of the mediation. How it started was, well, there was a plenary session. The mediator was appointed also under the rules of the LCIA, a Queen's Counsel, and he heard both sides, where he gave half an hour each, and we poured our grievances out. So therefore, we got all that was pent up in us out of our system, each one sort of, unreservedly accusing the other of not playing his part or not really being ethical about the whole thing. Then what he did was, he retired both the parties. Now, this started at 9:30 in the morning. He retired both the parties to their chambers, respective chambers, and he kept on shuffling between one chamber and the other. So he asked us, said that, look, can you come down in your demand a bit? Went to the other side, asked them if they could up their demands, etc. Now, this went back and forth. Then it got into lunch break. So we said that, look, can we be excused, or rather we just step down and pick up a bite? He said, no. He whipped out a menu card and said, look, why do you have to go down? Whatever you want, we can have ordered for you. So he did that. He kept us seated. Cut a long story short, eventually this back and forth, and at 12:30 in the night, which is 15 hours after the start, we actually struck a deal. We actually came to a consensus. Now, my son Sharan was with me in that. He was appearing with me. And at the end of it, he said, Dad, you know what this amounts to? This must be the most expensive butler service in London at the moment. I mean, that's how we combined. He just didn't let any of the parties out of his sight. It was so dogged, so persevering, and of course, with the requisite wherewithal and knowledge as to how to push it forward. Now, that sort of a thing is woefully missing in our jurisdiction, but we just don't have it. You have a couple of renowned mediators, etc. In fact, the mediation was also resorted to resolve this Ram Janmabhoomi issue, which of course flopped then. But the point of the matter is that it is a matter of structure, it's a matter of orientation, and it's a matter of culture. It just doesn't exist in our country right now. So my experience is that mediation is looked upon as, all right, if a judge suggests it, humor him and go in for a mediation. But you know, the bottom line is that it's not binding. And that really seeps into the way in which you approach the whole mediation process. So as far as we're concerned now, I don't think we have the infrastructure or the right orientation to take mediation seriously as it could be taken. Whereas, under the LCI, as I said, a mediator, for instance, doesn't double up as an arbitrator. These are two different skill sets. And if you're a mediator, you're not an arbitrator. If you're an arbitrator, you don't venture into mediation.
I think that's a point well made. Ryan, we'll come back to you.
Yes. Yeah. I got your question now. Sorry for the time lag. Are big ticket corporate clients receptive to mediation? Frankly, my answer is not quite yet. initially, as Harish rightly pointed out, it's a culture which is slowly getting to grow on people, but hasn't yet grown with the pace at which it should. Which is also with arbitrations. Arbitrations also took a little time before people started going free flowing into arbitration. Harish rightly said that the concept of a mediation is different from the concept of an arbitration, and the skill sets required are different. And till those skill sets are acquired to the extent with which the big corporates feel that their issues can be serviced, you're not likely to have a lot of mediation in the immediate future. However, one thing I do feel is we should take advantage of one simple fact, which is that today, post the lockdown, people have got used to a lot of virtual hearings. People have got used to a lot of virtual arbitrations. And there is no reason why mediations also cannot take place under the same this thing. You know, we could link up from different parts of the world, get experienced mediators to come in and start slowly tackling one problem at a time. And it's only when the big corporates realize that this is an easier, more cost-effective way to solve their problem that they will come forward in a big way. It's also something that a lot of their general counsels have to be used to. It's a culture that has to be first imbibed by their general counsels before the general counsels also lean towards the mediation. That's what I feel where we are at the moment.
Mr. Manoj Singh, would you agree with the other panelists on, would you agree with one view that we have from Mr. Chandok that it is a very powerful medium, it is pretty successful, we need to bring in more awareness, and on the other hand, as we heard Ryan say that this is something that the corporates have still not fully accepted it. Which way would you think the subject lies?
Yeah, Mr. Nankani, perhaps you read the question on my face. And yeah, so we can examine it from 2-3 perspectives. First of all, I had some very good experience with the mediation. And in India, mediation require more legislation, some more crystallized framework. But framework is completely not there. I disagree with due respect. If Section 30, as soon as we read of the Arbitration Act, then anything under Section 30, you put it, it becomes a award which is enforceable as any other award. And then Section 73, 74 of the Arbitration Conciliation Act would be there and settlement agreement would be binding. Now, what the point is, the point I'm making is like this. I was in the beginning of my career 20 years back in the panel of chaired by Lord Mustill, Mr. Jarvin from Jones Day and Mr. Subbarao, the huge arbitration. And parties finally mediated and the issue was resolved, the money was paid. So mediation is impossible. I disagree. Mediation is in infancy in India. I agree. But in infancy, not due to the unavailability of the infrastructure system. There are enough infrastructure in the form of the legal acts and etc. that the mediation can be attended very successfully. However, I agree to the point. The core point is it is about training, and somebody need to take up it as a practice area. The different set of professionals are required, right? If you ask Manoj, you like criminal law? I said, no, I don't like criminal law because I don't know anything about criminal law. So similarly, perhaps we are a practitioner of barring Mr. Chandok or Mr. Bhasin. I know personally that doing something really very serious in mediation, attempting something very serious in mediation, but we are not a practitioner of that particular branch of the law, I would say. It is not an intermixed branch of law. It is a separate branch of law. I remember, and see, there is some confusion in the framework, legal framework, no doubt about that. I give you a second example where I was one of the counsel. Court said that, okay, you guys want to mediate? We said, yeah. I mean, we were from the complaint side. In anticipatory bail, we said, we want to mediate. We went to Delhi High Court Mediation Center. And now, later we found that mediation happened. We signed it. One of the trained mediator, I mean, I must take his name, Mr. Batra, did all well. And it was mediated, the agreement was drawn. But when after a year, the client was looking at my face, I mean, as a fool. I mean, later on, there are a couple of judgments which confuses it, that any mediation in the criminal case will not be having a similar value as from under section 89 it should go, and it will be judicial decree or not. So it is directly enforceable. The settlement agreement reached in the mediation will be straight away equivalent to decree or not if that mediation has happened during the criminal case. Now that is the issue, and perhaps the larger bench is examining again in Delhi High Court. So some clarity, some infrastructure, some legal framework is required. But to me, the most important thing is the proper trained professional belonging to that particular cult. I mean, this is my take on mediation, and it will grow definitely. Last example, when the same corporate, I mean, I'm sorry, I'm taking this question you put to Raian. The same corporate, when, and then me and Vikram, I know at least we are doing this kind of stuff. When we are same corporate we are serving in India, they are very skeptical, sketchy about the mediation process due to all the reasons. But when they go outside the country, for example, in US, if the other side offer you mediation, it is a compulsory for a lawyer to tell to the client that mediation has been offered and you must sit for the mediation, right? So cultural issue will evolve definitely, but the people belonging to the cult and properly trained is a must go to me if we really want to grow it any further. This is my take, Vikram.
Vikram, can I just intervene?
Sure.
Some observations
Certainly
can be dealt with by the worthy panelists also. You posed a question to Ryan, and Manoj also referred to it about whether the clients take mediation seriously or not. I think it largely depends upon how much you can create a confidence in the clients to mediate, I believe, and I always tell my clients, and that is my motto, which my office follows: a bad settlement is better than successful litigation. Now, if we tell as professionals, and that is our professional duty, professional responsibility, to tell the clients that, okay, you have a dispute, but try to resolve it. If you have to give, there has to be a give and take. So I think that sort of a mindset has to be developed. But if it comes from the lawyers to the clients would definitely take it seriously, that yes, it has some merit, because the client reposes confidence in you as their legal advisors. Second point is that, do we have trained mediators who inspire confidence in the parties that yes, they are not taking a one-sided approach, they will be fair, they will assess the factual position, they will assess, the legal position, and then try to mediate, in the dispute. My answer is, we do not have trained mediators. And one point arising out of this is, why should only lawyers be mediators? Why this emphasis on legal professionals everywhere? I think we have experts from the engineering background, chartered accountancy background, company secretaries, we have those people. They can also inspire confidence. By making, only lawyers involved in the process of mediation, that is, I think, counterproductive. And so is the case even in arbitration. We see, arbitration being cartelized only among the retired judges, and in some cases by the lawyers. We have to broad base everything if we are looking at solutions, So that is my take on that. Sorry to have interrupted.
Vikram, if I can also come in
welcome comments.
Vikram, if I can come in, just keep the discussion free-flowing to take further from what Lalit said. One of the things I feel is that today, if you look at our profession, attendant to it, we have a large amount of knowledge coming out as to what is happening in the courts. Bar and Bench, Live Law, other online magazines constantly keep lawyers and others updated. Now, if somehow mediation could also be brought into that, and there could be a separate sort of section or separate sort of reporting as to which mediations have turned out to be successful, who are the people who were mediators, then suddenly the bar itself will get much more familiar with the whole concept of mediation. Clients themselves will go and get an idea that, look, that person, that particular firm went to mediation, they came out of it successfully, they can double check with them and so on. And I'd like Manoj to give his views on this. Manoj, what do you think of the idea? You're mute.
Yeah. So then definitely training, I mean, nobody can say no to the training. Perhaps you are hitting that point. But
No, not only that, I'm saying reporting, Live Law, Bar and Bench, suddenly reporting which are the judgments, which are the mediations which have been successful. And, the most prominent which was not successful was Ayodhya. But there are so many smaller litigations, mediations, commercial and otherwise, which are successful. Now, which are the ones which are, once they get reported, then people start getting confidence in the whole process. That was my point.
Yeah. No, before we get Manoj Singh's views on this, we have certain statutory impediments. We have Section 42A. These are all confidentiality matters. And one of the key driving forces why parties choose a system outside the court or the state mechanism is to maintain confidentiality. So this is something which is going to be a painful path, and in future if it opens up. But my immediate question in the context of mediation, and probably a wrap up, because we need to also not ignore arbitration, which is a more popular sibling of the two, is again to both the senior counsels here, Mr. Chandok and Mr. Jagtiani, is that we have seen Section 89. It has been there for now almost 2 decades. But we have the recent advent of Section 12A in the Commercial Courts Act. In your practical experience, while we are talking about awareness amongst litigants about mediation, in your practical experience, how often have you come across a court vigorously enforcing Section 12A and saying, go for conciliation at a pre-litigation stage? When I Googled before this panel discussion, I found 1 or 2 judgments of the Delhi High Court only on this subject, but not otherwise. So how will the courts be responsible in spreading the awareness?
Let me take that on you, Vikram, to request you to please consider that the statutory provision provides for a compulsory pre-litigation mediation. But an exception is created that if you're wanting an interim order to go through and therefore you file that. So most of us, with all lawyers around with their ingenuity, would bring some application and say that mediation, therefore I did not go to mediation. Therefore, I think the role the court has to play is, even if a plaint is filed or I'm seeking an interim order, the court must examine, is it that very necessary? Or I could have waited for, because the mediation is not going on and on. There's a time limit provided in pre-litigation Section 12A and the rules that have been provided. Therefore, the court needs to be aware of the fact that how important it is. And that's why I think one of the suggestions that are being made, and probably I don't know when will get implemented, is that 1 sitting at least or 2 sittings of mediation is compulsory before you, unless there is something which is eminently happening. Now a demolition or something is going away, taking away part of the siphoning away everything. That could be something the court may say, okay, I'll stay in the hands of the other side till you go to mediation. The only question is, the judges do not insist on that. The moment the application comes up in a short matter before there's a supplementary list, in Delhi High Court also we found, but there are certain, I give you an example recently, even in the Supreme Court, Justice Call, after the litigation was fought all through and we reached the Supreme Court, the first question that when I stood up, his lordship said, what happened to you? You did not suggest mediation. No, I said, we are ready for it. But the other side refused. The other side said, now I am ready. So that's where the judge plays the role. So if the judge prepares the parties that what are the roles that people will have to play if they go to mediate, long battle will be fought faster, to my mind. Therefore, we need awareness among judicial people, judicial services. In fact, in the The academy must teach what mediation is to their judges also. It's not the lawyers only. And only to bring one more suggestion, one more add to what Dr. Bhasin said, I only wanted to bring to his notice that we have now gone to the company secretaries, because if you see after section 94, 95, 96 of the IBC, which has come into play now, where guarantors are now being going, there's a repayment plan. Though the words, the statute of the code does not use the word as mediation, but it says party will sit down to negotiate with each other. Now, the repayment plan. So that is where we have introduced mediation now. We started training the RPs. We have started training chartered accountants. So we are not confining ourselves now to lawyers only, but to add to that one precaution. As I think Vikram started by saying, so that we probably at the end of the day, when we're wanting to rejoice our settlements, agreements, we don't look at what clauses we are adding. What is happening is that many times we found that the settlements that are drawn, and now that we have India is signatory to the Singapore Convention, we are going to probably adopt that in our domestic law, then probably the settlements itself would be, you don't need to go to court. The settlement itself would be enforceable in law. Therefore, need for a, even if you take somebody, even if he's a chartered accountant and he takes aid of Mr. Manoj Singh or Vikram to settle that settlement, it's worthwhile. And that is why we have now introduced a committee like we have in ICC, we have in LIAC, where a committee that looks at the award to see, not that they adjudicate, but tell them that these are the clarifications that you need to give. Therefore, those precautions are being taken. We have gone outside the field of lawyers now to train people to make capacity building with respect to every commercial dispute. Otherwise, mediation was confined to probably survey matters between husband and wife, child custody, all that. But we have now traveled a lot. And I wanted to bring a big ticket situation of BHEL, where I mediated a 750 crore claim and we were able to resolve the matter. So it's possible that it's possible. The only thing is we are not giving it a trial. And I want to also bring to notice of my eminent friends, we have enough mediation talent in this country today. What we need today is enough available. We need to train our people on cross-border. Yes, I agree. I need to look at that. But in the domestic law, in the economic laws, we have capacity, especially in Delhi, Bombay, Calcutta, Madras, Ahmedabad to some extent. Lucknow also I found lately a commercial matter was referred to mediation. So this is, it's growing. The only thing is the bar will have to play a role. Instead of my only taking a view, and I'm glad Manoj is here with me on the panel, that the Bar Council only taking a view that I need to look at my supremacy, has to look at these aspects of to bring in. And now that Bar Council of India has made mediation as a compulsory subject in law now. They have started now teaching law in the Amity and other universities. So therefore it is capacities building. But yes, we need to, as lawyers, bring to the notice of our litigants that how good, how cost effective, time effective, especially in a commercial dispute, it is if you resolve the matters by mediation. That's all. Thank you.
Harish, any experiences where you have been in a situation either trying to persuade the judge to give parties a chance under Section 12A of the Commercial Courts Act, or in a situation where you have resisted such an application?
I'll tell you, from a very practical point of view, I find that the judges recommend mediation normally in disputes like a family dispute, or it's an old partnership which has gone. It's very convenient. And look, I'm being a little cynical here because I do suspect that half the time the judges are suggesting this to fob the matter off because they don't want to carry on with the case. And that could be one of the reasons, because it's really in one sense lip service. Where mediation probably assumes some sanctity in the law is, I have seen many arbitration clauses which say that the parties first shall endeavor to resolve the matters through a process of mediation, and whatever disputes are resolved, the residue of which will then go in for arbitration. Now, these are clauses, and I think that they are in that sense salutary clauses, because then one has to make a serious attempt to show that you've gone through that process of mediation so that your arbitral processes are not treated as premature. So there it is. But really, frankly, and I really don't have much more to add than what Mr. Chandyogi said, it really all depends upon either the judge or the mediator to carry this. They must have a thorough knowledge of what litigation is all about. and how expensive and how disastrous it can be, if it really goes to logical extent. So that is really what they must try and impress upon the mediator, or the judge must impress upon the parties before him that, look, it's not a walk in the park. If you're going to arbitrate on an issue like this, it is going to take its toll, and in many which ways. Therefore, these are areas, and for that, the judge or the mediator must have an understanding that, look, these are areas that can easily be resolved here and now. Otherwise, the litigation could fester. So it's really, in one sense, coming back to having the necessary skill set and a comprehensive understanding of law, litigation, and the system. That really will go into it. And I still think that we are in a fledgling stage as far as that is concerned. So from a practical standpoint, I really think at the moment we are still at the level of lip service to mediation, and it hasn't really taken roots.
Great. It's always nice to have diverse views on a panel like this. But let me now move over to arbitration. And again, let me pick a question which may be sensitive, but at the same time has a lot of practical relevance. And I'll take this question to both Raian and Manoj Singh, because as far as the client is concerned, the first port of call is Raian or Manoj, and then it goes to the next level when, arbitrators come in, counsels come in, etc., etc. So on the topic which Dr. Bhasin raised and Mr. Chandok also made a mention of it, what would be a typical reaction of a client if you suggested appointment of a non-judge as an arbitrator? Raian?
Appointment of a, sorry.
Hesitant.
Yes.
Hesitant.
Non-judge.
He would first be a little hesitant. We would have to convince him. We would have to point out the advantages. And for that, we ourselves, see, look, when you say non-judge, what you mean is a non-legal person. Because a lot of people are happy to have a lawyer as an arbitrator. In fact, a lot of people prefer a lawyer as an arbitrator to a judge because the lawyer is more day-to-day in touch. A person who's not a busy lawyer can still make a very good arbitrator. He's day-to-day in touch. He's under the scrutiny of the whole bar and so on and so forth. A retired judge is a little more isolated, is a little older, is a little more tired out. So between a non-judge and a lawyer, no hesitation in making that shift. Between a non-legal person and a lot. Because also you have to understand one thing. It's not just a matter of that person's ability to think out things and see the problem through. People are just not familiar with engineers. People are just not familiar with commercial people. People don't know how they will react. People also have a sense that some of them may sort of, be more susceptible to an outside influence than a judge or a lawyer would be. People expect and assume that a judge or a lawyer just wouldn't have any friend who could walk up to him and say, listen, boss, this is a great arbitration, go this way, go that way. People are not so sure that that would apply to a person who, say, for example, is day-to-day in the commerce of life, So there would definitely, according to me, be a fairly high level of hesitancy. And frankly, even supposing I were to be told, why don't you appoint this industrialist as an arbitrator? I can think of an industrialist as a mediator. But to an informal mediation, he gets two parties together. He said, hey, you do this, settle it. That I can understand. He brings his clout to bear. But to suggest an industrialist or a business person as an arbitrator between two commercial disputes, unless both sides knew that person very well and had great faith in that person, I don't see them jumping forward to saying, yes, my commercial dispute will be settled by a third party who I don't know anything about. Somehow, whether you like it or not, our profession has still got that stamp that when you come to us, we will deal with it in an impartial kind of way. We will deal with it in a measured kind of way, and we'll deal with it in an intelligent kind of way. You can't really say, and also you have to understand one other fact, Vikram. An arbitrator who is a judge or an arbitrator who is a lawyer has a body of work. A particular judge has given 15 arbitration awards. So you can assess how he is. When you're going to a businessman for the first time, you won't know whether he'll give a good award or whether he will even be able to put it all together in the way in which he should. So these are all the facts I feel which would come in the way of a non-legal person being appointed an arbitrator.
Thanks, Ryan. This is you, very candid, very honest, very hard-hitting, and appreciate that. Before I go to Manoj Singh, I just thought that let me flag some areas where you could potentially consider, and when I said non-judge, I did not mean a non-lawyer. Of course, I meant a QC or a senior counsel or any other lawyer, because we know that in UK, in Singapore,
Correct.
Australia,
Absolutely.
Councils have made a career out of arbitration and mediation. So
Absolutely.
it's not that, so they stand in the same bracket as non-judges. But there are many areas which I'm sure all of you know. For example, in construction arbitrations, you can have quantum experts. In shipping matters, you could have experts. In matters relating to valuation of shares in a joint venture dispute, you could have chartered accountants. So my question to you, Manoj.
But all those are specialized.
Yes.
You see, you would have to pick out that particular kind of matter and then take it outside the ken. Those are specialized. No doubt about it.
Absolutely. So
because also those are matters, Vikram, where the technical aspects override the legal aspects.
Right.
So it's such a technical subject that frankly the judge or the lawyer may be a little out of depth.
I agree. So precisely that, Manoj, in your experience, how would you go about recommending a good arbitrator to be appointed to a client? How would you convince him if he was sitting with you in a technical matter or in a financially complex matter, whatever the case may be? And have you really succeeded in appointing other experts from other areas?
Yeah. So, Mr. Nankani, it's a very good question, and it put me in very tough spot. I mean, as Mr. Chandok pointed out, I sit in the Bar Council of Delhi also as executive chairman. So it is my personal view which I'm going to give now. So, I know Mr. Bhasin is absolutely diagrammatically opposite to my view. He has been my mentor for more than 2 decades, but I have an absolutely different view. I'm more utilitarian philosophy man, and I personally feel, I may be unrealistic, but I personally feel that I don't want to change the system in a day. I want to live in the system. Now, take a situation. The only cause which all the very eminent panel can look into, why Reliance Arbitral Award has been set aside by the Division Bench of Delhi. If you ask me core question, core reason, single reason, because the technocrats, good arbitrators, fail to recognize that while passing an award, the tribunal cannot set aside the statutory tribunal which has decided about the speed findings, right? So I would like to bifurcate into 2 buckets, legal mind, non-legal mind, right? We like it or not, we may keep on calling it as about party autonomy and flexibility, but across the globe, all the arbitrations are governed by the domestic acts, which are by and large the incestual model. Now, within the act, at least a couple of jurisdictions, I would say more than a couple of jurisdictions, I had been participating. Everywhere they say that the principle of the law should be looked into. I want to pose one question to myself. If somebody is not trained in law, while passing an award, how that person will look into the first principle or the best evidence rule of the law? I keep on encountering with the specialist also now coming as a techno-commercial advisor, especially from the NHI side and some other public sector side, to argue the matter. In the re-examination or the general cross, they ask to reiterate what is written in the affidavit. They ask the interpretation of the law. Now see, the basic, what is your act? You have to live today. Somebody will change this arbitration act tomorrow. I have no difficulty. I would like to learn that act on that day. But today, what your arbitration act says, if you read the total 34 and 34(2)(a), I mean, it is about the principles of law. If the award is not principles of law, then it will not pass the test of the law. Now they are coming more closer. They are trying to rationalize the flexibility by saying illegality, irrationality, and improper procedure. Famous triple I principles. One of the judgments Supreme Court has just tried to bring in those. Singapore Supreme Court has attempted this couple of years back. The expert, to my mind, and I'm sorry, I know definitely Mr. Bhasin has a strong view on that, but to my mind, I'm doing blasphemy against my mental point of view, but I have to do it, sir. Now, to me, if you want to bring in an expert, why do talk about construction, Vikram? Right? We can talk about the maritime, where the specialists are required. You can always bring in the specialist as an expert witness to depose.
Correct.
Who stops
That's
you?
right.
And he will bring the point. So I'm trying to connect it the last question of the Raian, which at that time you moved on, whether it's mediation or whether it's arbitration, the awareness, you have to bring it awareness. Ryan put very important point. You have to bring in the awareness. I want to ask question to whole of this panel. If somebody is not trained in law, how he will observe the principle of law while deciding the arbitration case or while passing the award? Over to you, Vikram bhai.
One point I may also make here is that, ultimately, when it goes in appeal, it goes before a judge. Now, there is always a natural inclination, sometimes, I feel, subconsciously or unconsciously, to be a little more harsh if the person giving the award is not of the brethren. You're just more likely to find fault with that person than you will find fault with the person who you sat on the bench with a few years ago. It's just human. And that's another factor that every client has to factor in when deciding as to who he wants as an arbitrator. Vikram, I'm going to be here for a little while longer. I indicated earlier, I've got my alma mater, not the one in which Harish taught me, but my earlier alma mater, Shriram College. I'm on the governing body, and this is my first meeting over there. Sure. I've just been inducted, so I don't want to give it a complete miss.
No difficulty, Ryan.
Thank you.
Be comfortable, and whenever it's convenient.
Thank you. Thank you so much. It was lovely being with all of you on the panel, and it was an extremely exciting and illuminating discussion. Thank you.
Thank you. Which takes me now to Mr. Haresh Jagtia, because while we hear all of these issues with the ground realities, which both Ryan and Manoj Singh said about appointing non-judges as arbitrators, we are making the seminal mistake of bringing in the baggage of civil courts into arbitration, and that, I think, destroys to a large extent the real essence of arbitration. Because if we every time are going to examine it from the lens of how a lawyer would do it or how a judge would write this award, then I think that itself destroys the very foundational advantage of arbitration. So what then, in your view, would be the yeses and nos of arbitration? How do you avoid the landmines so that we have a successful, seamless arbitration?
Yeah, Vikram, thank you for asking this question, because there is a bit of thought that I've given to it. One is that, really speaking, this jurisprudential concept of arbitration is something which the judge must first imbibe. And I'm talking about a judge who then oversees, or who's then evaluating the merits of an arbitral award in his jurisdiction under 34, 37, whatever it is. And I think what underlies the whole concept of arbitration is that the arbitrator has the right to be wrong. That is something which a judge or which the system must understand. I was speaking to a counsel who practices almost exclusively on the arbitration side in England, in London. And he said that if a counsel succeeds in getting a judge interested in an arbitral award and admitting it, that counsel would be entitled to a gold medal, because it is so rare. It is so rare that it just never is entertained. There's a lot of latitude which is given to an arbitrator. And fortunately now, with the two recent judgments in Sanyong and Recon, which is a judgment of our Bombay High Court, I think these challenges have been narrowed down. have been narrowed down to, unless it's a, you know, it's a an obvious error, in that sense, a perversity, or it goes against the law of the land, patent illegality, etc. And all this has received such careful judicial interpretations and contours that, really speaking, in that sense, is limited. There was a time, of course, in our very jurisprudence, that the judges tended to be trigger happy, and not only that, but they even said that a jurist had commented that, look, the Indian courts are looking for an excuse to interfere with an award, and they actually called it, if there was the slightest connection with India, even if it was a foreign-seated award, they would interfere with it. And this is what the jurist described as a case of national overreach. Fortunately, there has been a tremendous correction course in that particular attitude and approach, and now it's come down to being very narrow. But nonetheless, in practice, I still find that some of our judges are pretty trigger happy and would then go out of the way to call an award perverse, only to be able to then have something to say about it. Therefore, this mindset has necessarily to be changed from the point of view of the judiciary more than anything else. This is one of the things which one has to be. Now, what has happened is, fortunately, in the context of these judgments, the recent judgments which have been pronounced, and I must say, I frankly think of all the high courts, the lead is really coming from the Delhi High Court. They're extremely proactive. In fact, this morning also, I read the newspaper report where they said that there was an award against the Future Group in an emergency arbitration under the SIAC, and the Delhi High Court has said, yes, that is perfectly permissible, because an emergency arbitration actually predates even an arbitral tribunal being appointed. It's limited. It says, yes, certainly we're bound to follow it. Not only that, they have cautioned the person that if you don't obey the award, you could even face civil imprisonment under the provisions of Order 39 of the CPC. Now, this sort of proactive approach of the Delhi High Court is certainly making waves. And I must say, the Bombay High Court is not too far behind, but it is certainly behind. And that's from my experience. And I'm not mincing words over here. So therefore, this concept is coming in. Now, therefore, from a practical point of view, again, what happens in an arbitration if the arbitral award is founded on an appreciation of evidence rather than anything else? If, for instance, it's a witness action, evidence is there, and the arbitrator appreciates the evidence and gives his award, that really, in that sense, limits the interference with that particular finding. So this is one of the things where, if a matter goes in for arbitration, I think a person with trial lawyer skills has a bit of an edge. Also, what happens is that cross-examination of witnesses is far more effective in an arbitral proceeding, for the simple reason that, civil trials which come up after 15, 20 years, a witness goes into the box and an inconvenient question is asked to him, and he says, I can't remember, it happened 20 years ago. And it's perfectly legitimate, in the sense you can accept that he may not remember what happened 20 years ago. But a dispute which arises for arbitration is something which would have arisen recently, so that alibi or that escape route is not available to a witness. So witness actions are very, very effective in arbitral proceedings. And the extent to which an arbitral award is founded on an appreciation of evidence immunizes that award from challenge. Now, this, therefore, is how the scenario is changing in the world of arbitration. But I come back to my original point that jurisprudential concept of what it is, the arbitrator has the right to be wrong, is something which they must understand. And it stands to reason, because as was discussed a little earlier, that an arbitrator need not be a lawyer, he need not be legally trained. He could be a person who has absolutely no knowledge of the law, but he goes by what is considered common sense, a rational approach, as long as he's within the area of the dispute and he decides it. So those are some of the things that one has to keep in mind in understanding the whole do's and don'ts of arbitration.
Yeah, absolutely. Agree with every word that you say. Sorry, except that I will not respond to the example that you gave of the recent Delhi High Court judgment, because that is a conflict situation as far as I'm concerned.
I should have guessed.
No. But you're right about the fact that the courts must today have a mindset where they must learn to accept the proposition that the arbitrators can be wrong, but as long as they follow the due process in a fair manner and show transparency and equal treatment to both sides.
And if I may just add here, and the distinction drawn by this Sanyong judgment is a very valid distinction. It says if the arbitrator, or whoever he is, the arbitrator, applies a wrong law, in the sense a non the law and applies it in a manner which the judge doesn't agree with, but it is applicable in that sense, that can't be interfered with. And that is what I find that some of the judges in their jurisdiction under 34 find it unpalatable. They don't feel, they said, no, well, how could you have taken this? That's the point.
But apart from the law, whether the arbitrator gets the law right or not, I think fundamentally there are various procedural aspects and good practices which we have not imbibed into our system. So, for example, the chess clock method, that we know that in an international arbitration, you are given limited time for cross-examination. In India, it tends to get ad nauseum, and it goes on, and it's a delight for any lawyer to be part of those, because the sittings just spread. Then we have situations where there are no closing submissions in international arbitration. You have an opening introductory hour and a half session, and then you go straight into evidence and the live transcripts, and at the end of it, at best the arbitrator will ask you to file some written submissions or closing submissions, and that's the end. And it's all done on a trot. So there are a lot more things which we need to put in our system in place. And that takes me to the two important features of arbitration, and that is as far as speed and cost effectiveness is concerned. And therefore, my two questions to both the panelists, Mr. Chandok and Manoj Singh, on time and cost effectiveness. On time, Mr. Chandok, do you think that Section 29A has served its purpose or not?
You see, our experience has shown, and I wanted to just shift for a little bit to answer your first part that you said. I think the lot of disservice has done to the judicial jurisprudence or to the trial as such, by we brought that concept of, local commissioners or somebody else recording our evidence. And if you give me my I'm thinking Dr. Bhasin will be able to give you us better. But when I joined the bar, I saw the trial taking place in Delhi High Court. There, if the trial has started, unless there was some death or something, the trial would continue with the judgment. And to give you an instance, the judge would say, Mr. Chandok, I have seen the demeanor of witnesses. I have seen the cross-examination. Everything is before me. You tell me the points and give the answer, give clarification of these 4 points, and judgment goes through. Now, that is where I think with a strength of 60, for example, in Delhi, we have a 50% there. There's no appointments not being made and all that. If you probably had 60 judges in Delhi High Court, I'm sure we can go back to trial in the court. The trial in court itself. And what is happening in arbitration is the arbitrators don't check the cross-examination. And unfortunately, many of them have not done trials. Therefore, that is the problem area. So what I think the point that I'm making is that he may be any expert, whether he's an expert as a chartered accountant or anything, but if he has a domain knowledge of fundamentals of law, he will be able to appreciate evidence and put it in the award. And that's where I think Mr. Jagtiani really brought about the lead that the High Court has taken, where we saw that unless it's per incuriam, if it's a statutory provision, if even the court doesn't look at it, obviously the judgment is bad. But then where he has interpreted law in a particular way after noticing he has gone wrong, the judge will have to overlook it because it's a view that he has taken. He can't substitute his own. But the timelines has certainly brought a change. And you see that timeline that we have not only brought in arbitration, we brought in IBC, for example. It brought total change in character of people. The businessmen started looking at it, no, I can be put into insolvency tomorrow or a restructuring position. So the arbitral tribunal also knows, and I think with the fee schedule that is troubling many people in ad hoc arbitration is still not accepting the schedule given in the Arbitration Act. So if we make that into a point to see that the schedule is stuck, then you will find a lot of arbitration going by timeline. Though I see a sea change today in arbitration. What used to happen in 5 years is today happening in the timelines, unless there is something so complex, so commercially complex that it's difficult to finish that part. Possible, or maybe there are too many witnesses to give. Otherwise, most commercial matters will go around with the documentation, except with some small thing to be proved or not to be proved. And we don't need that proof, but we need to prove in a civil court. That's where the distinction must be drawn in an arbitration as well as in the civil court's jurisdiction. And once the arbitral tribunals are made aware, even if they are retired judges, with all humility at my command, many of them have not done trials. Therefore, they don't know the concept of a cross-examination also. That goes on. Even I will keep on asking any question that I want to ask, right from the childhood of the person till he passed away or did not pass away. So therefore, the question today is that we need, the timelines were important to bring the system up. And I think it has done its job to a larger extent. The timelines have proved better for us. And I'm sure with the change of times, we need to shift now. Also, not that I mean any disrespect to any honorable judges, but I think a commercial lawyer who is doing commercial litigation every day, he would be an arbitrator who will be able to grasp the situation much faster than somebody who is coming from, especially, let's be honest about it, except for probably a few parts of India, Delhi being at top today with 69% commercial litigation coming to it. How many people in Odisha would know what commercial litigation is? Let's be honest about it. So therefore, we need to bring that concept, and I keep voicing that, and I'm not mind even voicing this today, that if I find that tomorrow a judge has a potential to come to Supreme Court, it is better that you transfer him at least for 2 years or 3 years to some place where he gets knowledge of other branches of law before he goes to Supreme Court. Because that's where the whole problem has come. To give you just one example, I'm not meaning any disrespect to anybody. If you use specific performance judgments in 1 year, 7 judgments comes from one honorable bench of the Supreme Court, and all were different. Therefore, that is where the uncertainty of law is being created. So once we have that certainty coming in, I'm sure situation will change. And therefore, the arbitral tribunals were required to put that timeline through. It has succeeded to a large extent. And I'm sure 1 year period will be sufficient after the pleadings, etc., are complete for any arbitral tribunal to do that, unless there's so complexity or third parties involved or group companies involved that it may take a little more time.
I don't want to also transgress the line, but I think your example reminds us of the character of Mr. Bumble in Alice in Wonderland.
Yes.
With that, I'll move on to Manoj Singh. We heard Mr. Chandok say that 29A was necessary and it has served its purpose. But then we have this other controversy that at the end of it, you have an award in your favor, you have earned the fruits of labor, and suddenly we find that it has got stayed because the party invariably takes it to the next level, which is under Section 34. And the award is again stuck in court for longer than the time limit because 29A does not apply to courts. This whole controversy about automatic stay, no automatic stay, amendment here, amendment then, what are your views on that? Should there be one standard, just like in CPC? If it's a money decree, the general rule, the thumb rule is deposit the money and then say whatever you want to. And that would bring about seriousness in the party's efforts to challenge it or not challenge it, and honor the commitment and honor the award.
Yeah. So, Mr. Nankani, 2 things. Before I answer your later part of the query, I want to give my view on the 29A, on the timelines of the arbitral proceeding. Definitely, it has served the purpose. There is no doubt.
A little louder, please. A little louder.
Okay, can you hear me, Mr. Jagtia?
You're very soft.
Thank
you. It is uncharacteristic of you.
me and Mr. Jagtani appears against each other. So, thank you, sir. So, yes, so Mr. Nankani, what I am bringing in here is 29A has served its purpose, no doubt. If you see the average 14-year kind of the trial time frame in the district courts, we have definitely come down to 26, 27 months kind of time frame in all the arbitration cases. But there is a caution, two caution. First of all, as you rightly pointed out, that there must be equal treatment of parties, which is enshrined in section 18, and day one schedule should be fixed. If you are not fixing the schedule, you are traveling towards 50 different kind of interpretations on the timeline with the brilliance of Mr. Chandok or yourself or Dr. Basin or Mr. Jagtiani. You will find the timeline extension. The big caution is the latest amendment, which says till the time the court decide on the extension of the arbitral tribunal, the tribunal will deem to be sitting. Now, there can be a situation in certain of the courts, we know, I don't want to name, they where 29 extension applications are pending for more than 1.5 years, meaning thereby you are giving a 1.5 year extra to the tribunal post 24 months without deciding the timeline. I am facing such kind of cases in some of the states, and caution is, we know the 90 days amendments 2002, which in the leadership of Mr. Chandok and others has been fully watered down. We have, Mr. Chandok has interpreted number of times, we have read his judgment, that 90 days is not a sacrosanct, and then Supreme Court upheld it. The same happened to section 138 proceeding 6 months. Then it came to be, he will endeavor to 6 months. Tomorrow it should not be endeavor to 24 months kind of situation. So there is a caution today, which is looking very green pasture. If it go to this kind of casual interpretation, the only defect, if you ask me personally, and I am saying it, the clause which brings the amendment that till the time the concerned court is not deciding 29A application for the extension of time, the tribunal will deem to be sitting. This is the most dangerous clause, which is going to not benefit to the arbitration proceeding at all. There are many places the original side jurisdiction lies with the district court, and sometimes district court, you will be surprised, I don't want to name, I don't want to do blasphemy. District court judge asked that they are the sitting retired court judges, whether I can extend their timeline. I mean, you can't help it. And it's pending from years, please check it, it's pending for years, and the tribunal is sitting because they have not decided. So this amendment is the only caution. Now coming to the second point, Mr. Nankani, the money decree, it's a money decree. It's a trial. We need to understand it's a trial, as Mr. Chandok said. And I feel personally today that I'm quite lucky that whomsoever, all of us went to trial court, but perhaps some of us went more to trial court because there was no option in those days. It's a hardcore trial and it's a money decree. No question of automatic stay should be there. I am absolutely clean on my thinking on it. If there is a award, the honorable judges are deciding on these issues time and again. Two-way, number one, no fun in sending back to the tribunal that redecide this issue. That is now clear. That it has curbed the delay. It is serving the purpose of the Indian Arbitration Act or the arbitration per se across the globe. Now it cannot be sent back to the tribunal. If judge is not in agreement, either he has to set aside or he has to uphold the award per se. The second thing is that they are not substituting their own view. Wonderful, wonderful interpretations, and our own courts are giving those interpretations which we call purposive interpretation. The law which was developed by Lord Reed and Lord Diplock in 1985 in London, assimilated by Indian Constitution Bench in Tata Solar case, again I'm saying triple I, illegality, irrationality, improper procedure. These three are the touchstones of the any arbitration proceeding to me. If they are kept into mind, I mean, we are good. And more purposive interpretation will come, but timeline extension on the frivolous ground. I'm closing my response to your query, Mr. Nankani. The timeline extension by the court on the flimsy ground must be avoided. Otherwise, 90 days timeline to file it, 90 days timeline to file your response in a under Order 8, we know what has happened to it. And then you have come up with the new Commercial Act in 2015, which is again try to do the same thing. You know, one ombudsman gone, new ombudsman is coming. It will not help. It has to be the cautious approach by the lawyers, by the honorable judges sitting in the court, that timeline, if you start extending on the one ground or the other, the whole arbitration will fall to flat. Over to you, Mr. Nankani. Thank you.
Thank you, Manoj Singh. I mean, I can keep multiplying examples of how catastrophic Section 29A has been badly treated, at least at the district level. I, for one, have a personal experience where the district judge dismissed the application under 29A, saying that the applicant is a proprietary concern, but the cause title is in the business name and not in the name of the proprietrix. And he invoked Order 30 of CPC and said your application is not maintainable. Obviously, the cause title was a cut, copy, paste of the statement of claim, and that was an issue which the arbitrators were alive to. But as I said, there are problems, there are maladies, and I think they need to be rectified. But the positive side is that there is light at the end of the tunnel. Things are improving. And people are becoming more and more conscious and aware of the effectiveness of alternative dispute mechanisms, be it negotiations, be it mediation. I think multi-tier clauses in an arbitration agreement would be the flavor of the season, and I think we'll see more and more of these clauses being incorporated in the arbitration agreement. We have hit, I'm told on the chat group that we have hit the highest viewership mark of more than 1900 viewers. So we can't forget them, we can't leave them out. And we have 15 minutes to wrap up this section. So I would invite questions from our viewers, and please be free to send your questions on the chat group, and I will put it to the panelists.
Vikram, I just wanted to add something to the point that we were discussing. I
Sure.
think it's important only in this sense that, look, there has been a sea change in the pre-2015 and the post-2015 arbitration era. You know, one is, and this is something which should be of great concern to the nation as such. I don't know how many of people are aware that even as of today, 23% of the cases which are tried by SIAC are such where one of the parties is an Indian in cross-border transaction. Now that's a huge number. In fact, the law minister of Singapore makes 5 or 6 trips to India, hosts dinners over here, only to make sure that the importance of SIAC as an arbitration center is not lost out. And I must say, sadly, that we have been overtaken in that sense. We don't have a credible arbitration center, despite the fact that you have such a wealth of legal knowledge over here. You know, you're overtaken by SIAC, by the Hong Kong Arbitration Center. Even Dubai, of course, is now flourishing as far as arbitration is concerned. And even Sri Lanka is taking a far more proactive stand. Now, that is, I think, with the change in 2015, hopefully some of that would be arrested. But you're absolutely right. There should be, in that sense, a similar timeline provided under Section 34 as well, whereas there it's only an aspirational, saying that within, as far as possible, within a year, 1 year, it must be done. And that's observed more in its breach than anything else. But I think this is something which society must take notice of, because having an arbitration center is actually to lend a complete different intellectual flavor to this country, which we rightly deserve. But we are heading in the right direction, is my observation.
No, I think what is required is that the chambers of commerce of the country, various chambers, they have to take a lead in setting up good institutions of arbitration. We have had a only small beginning in Mumbai, in the Mumbai International Arbitration Center. But after 2015, I don't think there'll be any sea change. This effort has to be an effort by the private sector and not at the initiative of the government. So institutions have to come forward. Bar associations and the law firms and all, they can combine in setting up good centers of excellence so far as arbitration and mediation is concerned. I think that would be the answer to inspire confidence, and people don't go to SIAC or to Dubai or London, LCIA and other institutions.
Certainly right, Dr. Bhasin. I mean, we can't take away the credit from Singapore. It has developed itself into a legal hub, but I think India is not far away. We have all the trappings of a good arbitration center. We have a excellent bar, a very knowledgeable, legal system, and we have the right. We speak the right language. We are our English is that is one of the languages, a great factor when you look at some of the countries in Europe and in East and Far East, where this is considered as a challenge. And then, of course, we are very cost effective in terms of our legal system not being very heavy on the pocket. So we have all the right factors which can convert India into a legal hub, just as Singapore has done it. And I think this is the right time when the Honorable Prime Minister's concept of Atmanirbhar is being given the impetus. It's inevitable that along with that, when you have more of economic activity in the country, you must also have a good support system as far as dispute solutions are concerned. I almost said dispute resolutions, but I think let me stick to dispute solutions. Yeah, thank you so much, all of you. You've been great. And the viewers, as I said, we have got more than 1900 viewers on this session listening to you all. May I invite the viewers to send their questions, if any? We have about 7 to 8 minutes, so we probably will take 2 or 3 questions.
Sir, since we are using two softwares, can we please take the questions offline?
All right. Okay. So if we have to take the questions offline, I'll hand it over back to Dr. Bhasin to give his concluding remarks.
Thank you, Vikram. I think it was an excellent discussion on topics where we have not had good and meaningful discussions. The emphasis on solutions, and I think rightly so, all the panelists were of the view that we can create a proper environment in the country for effective solution of disputes. And that would also include to develop, negotiating skills, as I said, in the law schools. I was recently addressing the law students, and they said, and I advised them that please have something to do with the development of negotiating skills among the students, particularly in in-house counsel. You see, those in-house counsel who are there, as soon as some differences arise, they can sit with their counterparts and try to find out solution as to how a dispute can be avoided and the differences can be settled. So that would be a correct approach. But then we have to change the mindset of the people also, of our clients, that yes, they should have faith in arbitration. I remember one case where, I was told by my client, that look here, even the nominee arbitrator we appointed, he has also decided against us. It is that sort of an approach, which our people have. So one has to train them, that it is, arbitrators are also like judges. So you have to repose your confidence. Once you have appointed them, then forget that, he's your nominee or he's their nominee. They're all sitting as a proper tribunal. So some sort of awareness has to be created, in the consumers, that is the business people, to have faith and confidence in arbitration process and in mediation process. That is where leaders like Mr. Chandyok and all can really play a very important and significant role. I thank all the panelists. Mr. Vikram Nankani, you conducted it very efficiently, properly, and we had very fruitful discussion. And I'm sure that we have a record of this. Hopefully, we will be able to circulate, the deliberations of this very important session on dispute solutions to all of you and to our participants. Huge number of participants, nearly about 2,000 of them. So I'm very grateful to their participation. Thank you very much. Thank you.
Thank you.
Thank you, sir. Thank you so much.